The judgments and opinions of the court in two cases, 73-1046 Mathews against Diaz and 73-1596 Hampton against Mow Sun Wong, will each be announced by Mr. Justice Stevens.
In 73-1046, the case involves a challenge to the constitutionality of a portion of the Social Security Act which makes resident aliens who are over 65 ineligible for participation in a medical insurance program unless they have been admitted for permanent residence and also have resided in the United States for at least 5 years. A three-judge district court sitting in the Southern District of Florida held the statute unconstitutional. The case is here on direct appeal. As we point out in an opinion filed with the clerk, Congress, which has broad power over immigration and naturalization, has no constitutional duty to provide all aliens with the welfare benefits provided to citizens. The real question in this case is not whether discrimination between aliens and citizens is permissible, but whether the statutory discrimination within the class of aliens is permissible. We hold that the statutory requirements chosen by Congress, which render eligible those aliens who may reasonably be assumed to have a greater affinity to the United States than those who are ineligible, is constitutional. Accordingly, we reverse the judgment of the district court. In the second case, number 73-1596, the matter involves a challenge to the validity of a civil service regulation which excludes all persons except American citizens and natives of Samoa from employment in most positions in the federal service. In a suit brought by 5 aliens who had been denied federal employment for which they were otherwise qualified, the United States District Court in San Francisco sustained the regulation. The Court of Appeals for the Ninth Circuit reversed, holding that the regulation, although authorized by Congress and the President, was unconstitutional. Because of the importance of the question, we granted certiorari. For reasons stated in an opinion filed with the clerk, without reaching the question whether Congress or the President might expressly adopt such a rule, we hold that the regulation deprives a large and already disadvantaged class of persons of an interest in liberty and violates the Due Process Clause of the Fifth Amendment because it was not expressly mandated by either Congress or the President and was not adopted by an agency of the federal government having any responsibility for the national interests which are asserted in justification for the rule. Accordingly, we affirm the judgment of the United States Court of Appeals for the Ninth Circuit. Mr. Justice Brennan and Mr. Justice Marshall have filed a brief concurring statement. Mr. Justice Rehnquist has filed a dissenting opinion in which the Chief Justice, Mr. Justice White, and Mr. Justice Blackmun have joined.
Thank you, Mr. Justice Stevens. The judgment and opinion of the court in 74-1124 and 74-1110, Simon, the Secretary of the Treasury, against the Eastern Kentucky Welfare Rights Organization, and the related case will be announced by Mr. Justice Powell.
These cases are here on certiorari to the United States Court of Appeals for the District of Columbia. The plaintiffs are indigents and their organizations. They brought this class action against the Secretary of the Treasury and the Commissioner of Internal Revenue. They attack the validity of the IRS revenue ruling that extends favorable tax treatment to nonprofit hospitals that generally serve the community. The ruling entitles donors to take tax deductions on gifts to these hospitals. The ruling applies even though indigents are not served. The Court of Appeals sustained the validity of the tax ruling, but we do not reach the merits as we conclude that the plaintiffs did not allege a case or controversy under Article 3 of the Constitution. Although they do allege denial of hospital services because of their indigency, they fail to name any hospital as a defendant. The only defendants are Treasury officials. Nor does the complaint aver that the hospitals that denied the service were dependent upon tax-deductible contributions. Thus, it is wholly speculative, so far as the complaint shows, whether the tax ruling bears any relation to denial of the cities. We conclude, therefore, that respondents fail to establish their standing to bring this suit. The judgment of the Court of Appeals is therefore vacated and the case remanded. Mr. Justice Stewart filed a concurring opinion. Mr. Justice Brennan filed a dissenting opinion concurring in the judgment, in which Mr. Justice Marshall joined. Mr. Justice Stevens took no part in the consideration or decision of the case.
Thank you, Mr. Justice Powell. The judgment and opinion of the court in number 74-1270 trained the administrator of the Environmental Protection Agency against the Colorado Public Interest Research Group will be announced by Mr. Justice Marshall.
This case is here on writ of certiorari to the Court of Appeals for the 10th Circuit. It is a citizen suit brought under the Federal Water Pollution Control Act. That act makes it unlawful to discharge pollutants into the navigable waters without a permit issued by the administrator of the Environmental Protection Agency. The issue in this case is whether the nuclear waste materials, subject to regulation by the Atomic Energy Commission and its successor agencies, are pollutants within the meaning of the Water Act. We hold that they are not. In an opinion filed by the clerk, we hold that the regulation of these nuclear waste materials is controlled exclusively by the terms of the Atomic Energy Act. Since the Court of Appeals held to the contrary, the judgment is reversed. Mr. Justice Stevens took no part in the consideration or decision of this case.
Thank you, Mr. Justice Marshall. The judgments and opinions of the court in two cases, 74-768, Brown against the General Services Administration, and 74-1599, Chandler against Roudebush, will each be announced by Mr. Justice Stewart.
The first of these cases, Clarence Brown, petitioner against the General Services Administration and others, number 74-768, comes to us by way of writ of certiorari granted to review a judgment of the United States Court of Appeals for the Second Circuit. The principal question presented by this case is whether Section 717 of the Civil Rights Act of 1964, as amended, provides the exclusive judicial remedy for claims of discrimination in federal employment. The petitioner, Clarence Brown, is a Negro who has been employed by the General Services Administration since 1957. At the time this litigation began, he was classified in grade GS-7. In December of 1970, Brown was referred along with two white colleagues for promotion to grade GS-9. All three were rated highly qualified, and the promotion was given to one of the white candidates for the position. Brown filed a complaint with the GSA Equal Employment Opportunity Office, alleging that racial discrimination had biased the selection process. That complaint was withdrawn when Brown was told that other GS-9 positions would soon be available. Another GS-9 position did become vacant in June of 1971, for which Brown, along with two others, was recommended as highly qualified. Again, a white applicant was chosen. Brown filed a second administrative complaint with the GSA Equal Employment Opportunity Office. And after several administrative steps, the GSA rendered its final decision in March of 1972. The agency's Director of Civil Rights informed Brown by letter of his conclusion that considerations of race had not entered the promotional process. The director's letter told Brown that if he chose, he might carry the administrative process further by lodging an appeal with the Board of Appeals and Review of the Civil Service Commission, and that, alternatively, he could file suit within 30 days in a federal district court. 42 days later, Brown did file a suit in a federal district court. His complaint alleged jurisdiction under Title VII of the Civil Rights Act of 1964, with particular reference to Section 717, and also under two or three other jurisdictional claims, one being Title 28, United States Code, Section 1331, the general federal question jurisdiction,
another, the Declaratory Judgment Act, and still another, Title 42 of the United States Code, Section 1981, deriving from the civil rights legislation of more than a century ago. The respondents, the defendants, moved to dismiss the complaint for lack of subject matter jurisdiction on the ground that Brown had not filed his complaint within 30 days of final agency action as required by Section 717C of the Civil Rights Act of 1964, and the District Court granted the defendant's motion. The Court of Appeals for the Second Circuit affirmed the judgment of dismissal. It held first that the Section 717 remedy for federal employment discrimination was retroactively available to any employee, such as the petitioner, whose administrative complaint was pending at the time Section 717 became effective on March 24, 1972. And the respondents do not question that ruling. The appellate court held second that Section 717 does provide the exclusive judicial remedy for federal employment discrimination, and that the complaint had not been timely filed under that statute. Finally, the court ruled that even if Section 717 did not preempt other remedies, then the petitioner's complaint was still properly dismissed because of his failure to exhaust available administrative remedies. We granted certiorari to consider the important issue of federal law presented by this case. For the reasons discussed in the court's written opinion filed with the clerk today, we agree that Section 717 of the Civil Rights Act of 1964, as amended in 1972, provides the exclusive judicial remedy for claims of discrimination in federal employment. Since Brown failed to file a timely complaint under Section 717, the District Court properly dismissed the case, and the Court of Appeals properly affirmed that judgment of dismissal. Accordingly, the judgment of the Court of Appeals is today affirmed. Mr. Justice Stevens has filed a dissenting opinion in which he has been joined by Mr. Justice Brennan, and Mr. Justice Marshall took no part in the consideration or decision of this case. The second case in which I am authorized to announce the opinion and judgment of the court this morning is number 74-1599, Jewel D. Chandler, petitioner against Richard L. Roudebush and others, respondents, a case which is here on writ of certiorari to the United States Court of Appeals for the Ninth Circuit. In 1972, as I have just mentioned, Congress extended the protection of Title VII of the Civil Rights Act of 1964 to employees of the federal government. A principal goal of the amending legislation, the Equal Employment Opportunity Act of 1972, was to eradicate entrenched discrimination in the federal service by strengthening internal safeguards and by according aggrieved federal employees or applicants the full rights available in the courts as are granted to individuals in the private sector under Title VII. I have just read a quotation from the Senate committee report. The issue presented by this case is whether the 1972 Act gives federal employees the same right to a trial de novo of employment discrimination claims as so-called private sector employees enjoy under Title VII. The petitioner, Mrs. Jewel Chandler, is a Negro. In 1972, she was employed as a claims examiner by the Veterans Administration. In August of that year, she applied for a promotion to the position of supervisory claims examiner. Following a selection procedure, she was designated as one of 3 finalists for the position. The promotion was awarded to a Filipino-American male. The petitioner subsequently filed a complaint with the Veterans Administration alleging that she had been denied the promotion because of unlawful discrimination on the basis of both sex and race. After an administrative hearing on the claim, the presiding complaints examiner submitted proposed findings to the effect that the petitioner had been discriminated against on the basis of sex but not race, and recommended that she be given a retroactive promotion to the position for which she had applied. The agency rejected the proposed finding of sex discrimination as not substantiated by the evidence and accordingly granted no relief, since it accepted the examiner's proposed finding of no race discrimination. The petitioner filed a timely appeal to the Civil Service Commission Board of Appeals and Review, which affirmed the agency's decision. Within 30 days after receiving notice of the Commission's decision, the petitioner brought the present suit in a federal district court under Section 717C of the Civil Rights Act of 1964 as amended in 1972. Her suit was therefore timely under that statute. After moving unsuccessfully for summary judgment, she initiated discovery proceedings by filing notice of 2 depositions and a request for the production of documents. The respondents, the defendants, moved for an order prohibiting discovery on the ground that the judicial action authorized by Section 717 is limited to a review of the administrative record. The petitioner opposed that motion, asserting that she had a right, under 717, to a plenary judicial trial on the merits in the district court. The district court held that a trial de novo is not required under Section 717 and that review of the administrative record is sufficient if an absence of discrimination is affirmatively established by the clear weight of the evidence in the record. Applying this standard of review, the district court determined that the absence of discrimination is firmly established by the clear weight of the administrative record and granted summary judgment in favor of the defendants. The Court of Appeals affirmed that judgment, agreeing with the district court that Section 717 does not contemplate a trial de novo, and we granted certiorari to resolve a conflict among the circuits concerning the nature of the judicial proceeding provided by Section 717C, an important and recurring question in the administration of this new and important federal law. For the reasons set out at some length in the court's written opinion, we hold that the district court and the Court of Appeals were mistaken in concluding that Section 717C does not accord a federal employee the same right to a trial de novo as private sector employees enjoy under Title VII. The judgment, therefore, is reversed, and the case is remanded for further proceedings consistent with the written opinion filed today with the clerk.
Thank you, Mr. Justice Stewart. I have the judgment and opinion of the court to announce in number 75-328, United States against Orleans. And for reasons stated in an opinion filed with the clerk this morning, the judgment of the United States Court of Appeals for the Sixth Circuit is reversed.